The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach,
Here.
Johnson, Dutton, Moody, Landgraf, Schofield, Gonzalez, Flores, Hayes, LaHood, Dyson. Quorum is present.
The chair lays out House Bill 1110 by Chairman Shaheen and recognizes Chairman Shaheen to explain the bill.
Thank you, Chairman Leach, Vice Chair Johnson, and members of the committee. So HB 1110 addresses the concern that many citizens have about reporting suspicious activity to law enforcement and then getting sued. The proposed legislation provides protections for citizens who report suspicious activity in good faith against civil lawsuits. With the increasing threat of terrible tragedies that are occurring, we live in a world where it's vital for citizens to report suspicious activities to law enforcement. Department of Homeland Security See Something, Say Something program is a national program that raises public awareness of indicators of terrorism, as well as the importance of reporting suspicious activity to state and local law enforcement. Unfortunately, some activities go unreported, resulting in terrible events. Vanessa Guillen had confided in family and fellow soldiers about being sexually harassed and feeling unsafe, but no one ever made reports. The 20-year-old U.S. soldier was eventually murdered. A woman in another state was in a train and was assaulted by bystanders, and other bystanders failed to intervene or reach out to law enforcement. So spousal abuse, human trafficking, gang-related activities are all crimes that fellow Texans can help prevent. HB 1110 provides protection when reporting suspicious activities in good faith. Mississippi, Florida, and New York have passed similar legislation. And finally, members, the bill is a refile that was passed out of the House 123 to 22 last session, but failed in the Senate. Members, I'm happy to take any questions, and I reserve the right to close.
Go over that legislative history one more time.
Yes, sir. This is a refile. It passed the House 123 to 22 last session.
Okay.
And then failed in the Senate.
Okay. Members, any questions? The chair will show Vice Chair Johnson present. Any questions, members? Okay. You've reserved your right to close. Does anyone want to testify on, for, or against House Bill 1110? Seeing none, Chair recognizes Representative Chairman Shaheen to close. The Chair will recognize Representative Dyson as present.
Thank you, Mr. Chairman. I close.
Members, any questions? Okay. Seeing none, the Chair will leave House Bill 1110 pending at this time.
Thank you, members.
Chair lays out House Bill 1495 by Representative Morales. Good afternoon. House Bill 1495 by Representative Morales. Go for it.
Thank you, Mr. Chairman, Vice Chair Johnson, and members of this committee. My name is Eddie Morales, and I proudly represent Texas House District 74. Thank you for providing me with an opportunity to lay out HB 1495. This is a bill designed to protect the privacy of civil jurors by ensuring their personal information remains confidential. This may sound somewhat familiar to you, Chairman, and I'll remind you all towards the end as to why. This has been done before, specifically by this chairmanship, and so I'd like to tie it at the end. HB 1495 was brought forward after a troubling incident involving a constituent of mine in Valverde County who faced serious safety concerns after serving as a juror. After the trial concluded, the defendant's family was able to access her personal information and contacted the juror directly, pressuring the juror about the verdict and leaving her feeling unsafe and vulnerable. The reason this happened is simple. Under current law, civil jurors do not have the same privacy protections that criminal jurors do. Currently, in civil cases, personal information collected during a jury selection is not confidential and can be publicly disclosed by the court. In my constituent's case, after the verdict was delivered, her information was shared, leading to direct intimidation from the defendant's family. HB 1495 fixes that. It classifies the juror's personal information as confidential, preventing unauthorized disclosure. Disclosure would only be allowed if the court grants permission after a valid request demonstrating good cause, as noted under subsection B of the short 1.5 pager. This bill strengthens our trust in our legal system by providing civil jurors with the same privacy protections already afforded to criminal jurors. It ensures the individual's safety by keeping sensitive personal data private and out of public reach. As I mentioned before, Chairman, you proudly were the joint author in the 86 regular session of HB 4173. What the Ledge Council aided us in doing and drafting this piece of legislation is basically took all of the wording from your legislation that you passed and basically incorporated it into this piece of legislation so that it could apply to civil juries. So you've done this before. It worked. You know, we're here because in that instance, it only applied to criminal cases, and now it's going to apply to civil cases. And with that, you know, there may be some testimony, but reserve the right to close.
Representative Morales, thank you for bringing this bill. Members, any questions for the bill author? Yes, Representative Schofield.
Representative, the purpose of your bill is to keep this information out of the hands of people who might retaliate against the juror. Would you welcome any new language that allowed it to go to other governmental entities for the purposes they may need it for?
Yes, you and I visited about this, Representative Schofield, and I've tasked my office to see how they're already doing it in criminal cases after the 86th regular session, to see if that's already sent over. You know, we discussed the ethical obligations for members of the bar and their duty to disclose or not disclose this information.
Yeah, that's
So
sort of a second question, but yeah, I just wanted to make sure that we don't put something that makes this so confidential that other governmental entities, not anybody's going to let it get to the defendant or somebody like that, but if other governmental entities need it for their purposes, that they can get it. But yes, the second thing you and I discussed was you need to pair this with talking to the bar about making sure that that our ethical obligations include not releasing the information, because the defense counsel is going to get it and going to have it, and you'd got to make sure they can't give it to folks who are going to retaliate.
Correct. And
which
so
is a different thing than this bill.
all of this information, it is my understanding, and the wording on the bill, it subjects it also Chapter 552, the Open Records Act. And so there is that discretionary tool available as to what is available to the general public, and also the trial court, the way that the drafting of the legislation allows the trial court to make a determination as to whether it will disclose that information or redact certain personal information. So we don't want to step into the shoes of that decision maker. We think the tribunal is there and can satisfy that process, and that will take all of the effective measures, including taking into account Chapter 552.
Thank you.
Good questions. Representative Flores.
Just a quick question that somebody raised to me, and it's about if a person is representing themselves and so they request the information and get that information, how do we make sure that that person doesn't disclose it to others, or how do you retrieve the information once they're, you know, if it's released to them?
It's my
for their
information
use?
that right now in criminal cases, once the case is done, all of that information with respect to the jurors is picked up by the clerks themselves. That process, since I've never practiced, in 25 years of practice, I have had only the first 2 years that I practiced criminal court, in criminal court. So all of my experience as a professional in litigation has been on the civil side. And so that was never a process that we had to go through. And so I could easily see, when this problem was presented to me, I could easily see how easy it could be for this information to be disclosed to third parties and then abused. And so I know that we need parameters in place, and then when we saw that we didn't need to reinvent the wheel, that the chairman actually done this in the 86 regular session, it just made sense to use almost verbatim the same wording.
Okay.
Yeah. Vice Chair Hayes.
Thank you. Representative Morales, whether they get it rightfully or wrongfully, this information, what protections are there right now for civil jurors? That if one of the other parties is not happy about the jury's result, they take some retaliatory action?
Yeah, from what I understand, there are none. Obviously, this is just providing clearly noting that this is confidential information and that you will go through a two-step process. If you want this disclosed, you have to go to the court. But you're right. I'm not aware of whether there's any penalization section attached to this. And so that may be, if we continue to hear of these issues, that may be a subsequent issue that I'm going to have to address at a later time.
All right, and then, it's kind of been our practice for many years, we might write a thank you note to the jurors, and thank you for your service type deal. Would that be precluded, do you think?
Attorneys are still going to have access to this. Attorneys would still be able to send that information on behalf of their clients. We still, as a litigator, and, you know, we make most of our money in litigation, and we count on these juries, and I need to be able to continue to poll them, to continue to be able to visit with them post-verdict to see what strategy worked, what argument worked, what witness was favorable to them or that they counted on and to base their decision. I still need access to that, and I wanted to make sure that in this process that was still going to be there available for the attorneys. It's the abuse and this incident that we're aware of, and obviously it's not the first because it was enough for our chairman in the 86 regular session to bring it up in criminal cases.
All right, thank you.
Thank you. Vice Chair members, other questions? The chair will show Representative LaHood and Speaker Moody present. Members, any other questions for the bill author? Okay, thank you, Representative Morales. You have one witness who's registered to testify for the bill. The chair calls Will Basher. With Texans for Lawsuit Reform, I've got you testifying for the bill. Is that correct?
Sir, that's right.
All right. Thank you, Will. Go ahead.
All righty. Thank you, Mr. Chairman, members. My name is Will Basher, and I'm testifying on behalf of Texans for Lawsuit Reform for HB 1495. The integrity of a jury is crucial to a functioning democracy, and reasonably protecting jury privacy is important to upholding the jury's integrity. If a jury's in the jury box fearing that she's going to be retaliated against or harassed for making a certain decision or finding a certain fact-finding during the trial, then the integrity of that juror's decision and really the integrity of the civil justice system at large is going to be compromised. So we think HB 1495 is a very reasonable measure that's going to ensure that jurors, that their personal information is protected, and it's going to give them comfort that coming and serving on a jury and performing their civil duty is something that will not expose them to any later retaliation or harassment. And as Rep. Morales said earlier, this is really just plugging a hole in the law. Article 19A.104 in the Code of Criminal Procedure already protects grand juries' personal information, and similarly, Article 35.29 with broader language in the Code of Criminal Procedure protects criminal petit juries. So this is really just, again, taking that language, as you said, and applying it to civil petit jurors, and we think that's a really good thing for jury service. And just one final note, the Attorney General even penned an opinion in 2006 and kind of confirmed that there is this hole in the law, saying that right now there's no duty that a clerk or a judge has to keep a petit jury list confidential. So again, we think this is a really good measure.
Okay, good. Members, any questions for the witness? Okay, thanks, Will. Appreciate you being here. Does anyone else wish to testify on, for, or against House Bill 1495? Seeing none, the chair recognizes Representative Morales to close on the bill.
Thank you, Mr. Chair. I'd like to add, in my visit with a number of the membership here and our representatives on the House floor, that issue was brought up to me with respect to the Attorney General opinion, and now we had this issue. I specifically sent it to at least one member in this committee because of the insightful questions that were asked, and that's Attorney General Opinion GA-0422 that let us know that there was this hole in the system. Finally, I want to say jurors' safety shouldn't depend on what kind of trial you're called for. HB 1495 is about safeguarding privacy, protecting individuals, and strengthening trust in our legal system. I think that this goes a long way into doing that. I want to say and end my comments with, I am proud that TTLA, TLR, and CLEAT have joined in favor of this piece of legislation, and they allowed us to use their logo and material as far as distributing this material. So we know that, at least in the litigation community, there was support behind these entities and that are very involved here in the Capitol.
That's good, and maybe you can work with Representative Schofield on some sort of floor amendment to take some of his changes if you need to.
Yes, sir.
So, members, any other questions for Representative Morales? All right, thank you.
Thank you, Mr.
Appreciate you being here today. The chair will leave House Bill 1495 pending at this time.
That's the only matter I have before this,
Yep,
this committee.
it
May
is.
I be excused?
Absolutely, yes, thank you. The chair lays out HJR 112 by Chairman Frank, and recognizes Chairman Frank to explain the joint resolution.
Thank you very much, Chairman Leach and Vice Chair Johnson and committee members. I appreciate the opportunity to talk to you all today. Today, I'm proposing that the state of Texas add a constitutional amendment protecting the right of parents to raise their children. Over the past 100 years, federal law has outlined specific cases and has given parents the constitutionally protected right to make decisions for their children. But while case law currently protects this right, case law can be fragile and can change. Such a fundamental right deserves to be securely codified, I believe, in the Constitution itself. So the HJR is pretty short. It just constitutionally affirms a parent's inherent right to maintain the care, custody, and control of the children, to make decisions for their upbringing. The amendment prohibits the government from interfering with the parents' rights unless two very specific things. One, it's essential for the compelling government interest, and two, the actions are narrowly tailored to accomplish that need. So the purpose of the bill is essentially to codify what is existing case law as best we know, and I was asked some questions on the floor, which is great. And I think, while in a way it's a simple bill, it's a short bill, I think it's also very important, and it's important that each word is looked at. I am not an attorney. I have spoken to some. We've got testimony. We've met. I've got some comments from Justice Guzman and others in terms of what we think this does. One of the main reasons to do it, frankly, is when you want to defend your parental rights right now, your lawyer has to go to case law. This will make it much more simple. To the best of my knowledge, and again, y'all can ask questions and I'll answer, and we've got people a lot smarter on the law than I am. We are not changing or giving any more rights than currently exist. We are just putting them in the Constitution that makes it easier for parents who need to use them and make it, frankly, much less expensive for parents to use those rights. So with that, I'd be happy to answer any questions that I can, and the ones I can't, I might kick to smarter people than me.
Members, any questions for Chairman Frank? Okay. You've reserved your right to close. Do you have a question? Oh, I'm sorry, Representative Dyson, I didn't see you. Representative Dyson.
Somebody might be tired.
No.
12:30 night.
Yeah.
So it's a question I was asking you on the floor earlier
Yes.
about that is, my concern here, and have y'all looked at, are there any current laws or regulations that the state of Texas has in this sector that this constitutional amendment may cause either constitutional challenges to, or just people that will be looking into any changes of those laws?
Well, I don't think so. I think it's a great question. Obviously, CPS, and had some discussions with them on the exact words, and it's something that I think really you guys, I don't mean you guys, you should know. These are questions we need to discuss. We believe this is existing law. I believe that any of the, for instance, CPS removals, those would fit both 1 and 2. It's essential for a compelling government interest. We have found, the legislature, that it's a compelling government interest to remove children in certain circumstances. However, those actions also should be narrowly tailored to accomplish those needs. That's really what is my understanding of existing case law, and I'm certainly not an expert on all case law, but this is making it much clearer, but I don't believe it's expanding it.
Thank you.
Okay, members, other questions? Okay, thank you, Chairman.
All right, thank you, Chairman.
We've got 5 witnesses. I'm going to call a panel of 3 and then a panel of 2. The chair calls Steve Bresnan, Jeremy Newman, and Andrew Brown. And then Ms. Wood and Mr. Covey, you'll be on the next panel. Chairman, let me start with you. I've got you registered on behalf of yourself and as Vice President of the Family Freedom Project, testifying for HJR 112. Is that correct?
That is correct.
All right.
Yes. Members, my name is Jeremy Newman, Vice President of Family Freedom Project. Thank you for your time looking at this bill today. The Family Freedom Project does a lot of litigation on parental rights issues and obviously legislative work on parental rights issues. We've worked with Chairman Frank and with Chairman Hughes to draft this during the interim, and with kind of a panel of different legislative experts, judges, district judges. There's a letter being passed around from Justice Guzman, who was really involved in drafting this as well. And similar to what Chairman Frank said, the intent behind the bill is to place into the Texas Constitution rights parents already have, nothing more and nothing less. And we have 100+ years of constitutional case law that outline the rights that parents have. The issues that we are currently dealing with that we're hoping this will help solve are kind of twofold. The first one is that right now that case law is spread through over 100 years, and most of the time, in our experience, the attorneys that families can afford when these types of rights are in jeopardy are not the people who specialize in this area. Those people are expensive. And so you very often end up in situations where both the attorney and even often the judges who are dealing with these cases aren't familiar with the constitutional scope of the right that they're handling. And unless the parents can afford to get to the appellate courts, they often can't vindicate those rights. And so from that perspective, our hope is that it brings some clarity, and you don't have to have someone who's well-versed on the really voluminous case law to be able to vindicate a right that's so clearly stated in the Constitution. The second piece of it is to help ensure the longevity of that right, because right now it's in case law, and everybody knows case law is kind of fragile, right? And you can have new judicial appointments 20, 30 years from now with a different culture and different judges who have different views on the law, and those rights can evolve and change and even go away over time. And so what this bill does is it ensures that the rights parents have as they currently exist in case law are retained for future generations, and it kind of puts a bulwark against the threat that those rights would eventually possibly degrade or even go away completely over time. And Representative Dyson, as to the question that you asked, our perspective is no, that there aren't any laws on the books that are just blatantly unconstitutional that this would change. The expectation is that this would probably almost always be raised in an applied challenge, which is where the law itself is not facially unconstitutional, and the judges actually have to presume the law is constitutional. And an example of that is there was a case at the Texas Supreme Court in December, I believe, where there was a CPS case, and Justice Blackhawk actually mentioned this in his address this year. The O grounds is a way that CPS is allowed to terminate parental rights based on failure to complete services, and it doesn't necessarily have to be tied to a threat of harm to the child, just failure to complete services. And what the court found in that case was not that the law was facially unconstitutional, but that as applied in that case, it would be unconstitutional unless they read it to be really narrow, because basically their opinion was, we can't read this in a way that would allow the state to interfere in the parent-child relationship and sever that relationship if there's not any threat to the child. So we have to read it narrowly to avoid that. So that's the type of situation that it would maybe bring some clarity in, is we're not looking at situations by and large where we have whole statutes that are going to be struck down, because again, these are the same standards that everything's already subject to today. And it's really probably talking almost exclusively about applied challenges where we're making sure that as applied in a very particular case, that we're not applying it unconstitutionally. So with that, I'm happy to answer any questions.
Members, any questions for Mr. Newman? Okay, thanks.
Thank you.
Chair calls Steve Bresnan. Steve, I've got you here on behalf of the Texas Family Law Foundation testifying on HJR 112. Is that correct?
Yes, sir, Mr. Chairman.
Go ahead.
Thanks very much. I'm Steve Bresnan here on behalf of Texas Family Law Foundation, sitting with people who I've established friendships with, working on these very issues for a long period of time. We are neutral on the bill for the following reasons. I do think it's well established in Texas law and the United States law that parents have these rights. I don't think there's any disputing about any of that. Our members defend those rights all day, every day in the courts of this state. The neutrality comes from that the rubric here is not exactly the same language. In fact, it's quite different from the same language that's been implied in recent cases where it's a non-parent versus a parent. All the way back to the 1970s with the Amish cases, the Yoder case in particular, the Troxel case in 2000, the Dursap case in 2007, and NRA CJC in 2020, the language of those cases is that a fit parent has these rights, and that there's a presumption that a fit parent has these rights, rather than following what is a quite common description of analysis between being compelling state interest being required and being narrowly tailored. It's very common in the law, but that's not the language in the analysis that's been applied in recent years in the courts. So I'm glad to hear Jeremy make the distinction between facial challenges and as applied challenges, because each one of those cases is an as applied challenge. As I look over the statutes, I think the legislature's done a really good job of making it clear that things should be narrowly tailored. In 153.001 of the Family Code, which deals with conservatorship and child custody, it's clear that courts are supposed to make limited decisions or narrow decisions, and also 153, 193. I won't, unless you ask me to, I won't go back and read those to you. Switching over to the less run-of-the-mill but all too common cases over in the child abuse and neglect area, it's not hard at all to see that the state has a compelling interest in protecting children from abuse and neglect. So in the parent versus non-parent category, that most recently has been what's been established in the by the courts of this state, and by non-parent I would include CPS obviously in that as well. In the parent versus parent situation, it becomes a little bit dicier because someone's got to have the child on certain days of the week and for certain hours. And I suppose you could come up with an extreme case where someone was so deprived in the absence of any evidence of the time they ought to have with the child that could meet one of these constitutional challenges. But there's all kinds of remedies in the family code for that now. So all of that said, I want to be clear that an action of a court is state action. When it's private litigation, it's still state action because courts are making decisions. All of that said, as I look out over the family code, I don't find things that are objectionable on their face. I do think that there is a San Antonio Court of Appeals that applies this kind of analysis. Justice Thomas in the Troxel case, which was a plurality decision that seems to be governing most of the law in this area, advocated for this same kind of analysis, and the plurality rejected that. But as we sit here, I've not had any of our members, and I don't see from my experience in working with y'all on these bills that Texas Family Code has obvious gaps in it that would be negated or that would be vulnerable, for example, under this rubric. So I'll be happy to answer any questions.
Vice Chair Johnson.
I just want to pick up on where you said the interest of the parent versus another entity or organization versus a child. And I don't think this is at all Chairman Frank's intent, and I'm just asking out of curiosity. Having done juvenile justice issues, I have seen parents that almost treat their child like chattel or property. If we have a situation where we have legal protections where the child has a right to counsel, the child has the right to meet with counsel by themselves, and you have a parent that says, no, that's my kid, you can't do any of that, and effectively the parent feels like they have the ability to interfere with anything on the child's behalf. Do you think this constitutional amendment would, in essence, give a parent the power to intervene in that circumstance and give them a greater right to influence the child? Does that make sense?
No, I understand exactly what you're asking. To me, this has the issue, the first analysis is there a compelling state interest in the state of providing the child with counsel in a way that might be adverse to the parent's wishes? I personally can conjure up circumstances that there would be a compelling state interest in doing that, particularly the more that line gets over towards abuse and neglect, where in a way it's a conflict of interest for the parent in some of those circumstances. Then to narrowly tailor it, the right to counsel is a right that's enjoyed by human beings in most contexts. I could see how it could get out of bounds. I could see how people could use this arguments to contest that in a given case, but I think they could do that now as well. In that sense, I think this language is not frightening to me in that regard.
Thank you very much.
Thank you, Vice Chair. Yes, Representative Blowhead.
Thank you, Chairman. Mr. Bresnan, how would this constitutional amendment affect, let me read it, competing parenting decisions for the upbringing of the child? So, I mean, I guess my question, if any, and it may not, if both parents have an inherent constitutional right and they differ on their upbringing, like, would there be any effect on that? How does that work?
I think if we apply the analysis, the state has a compelling interest in making sure that kids have safe, stable homes where they get fed and they're supported and, all those kind of things that are in the interest of the child. In the family code, as you well know, the general test is best interest.
Yeah, I was going to ask.
Just before last interim, in the case of NRA CJC, there was a gap in the family code on modification cases. Texas Supreme Court read into that a constitutional fit parent presumption as part of the best interest analysis in those cases. So the courts filled in that gap where there was arguably a gap in the legislature, in the statute. There was a presumption, fit parent presumption, over in the general custody statute, but it wasn't in a modification statute, and the court read that into. That's the bottom line from NRA CJC. Again, that was a parent versus non-parent. So I guess we could conjure up an extreme case where I don't think compelling state interest is a concern. Whether the remedy fashioned by the court in a given case was narrowly tailored to achieve that interest, I suppose would be fair game for lawyers to question. If someone was so deprived of a right without the evidentiary basis to stretch that, then I suppose our lawyers are going to make arguments in that regard. Again, I think they can do that today.
And I think it's safe to say that if parents disagree on parenting, that's still, I mean, that doesn't get affected. All we're doing is codifying the parents and strengthening their rights as parents. Interfamilial disagreements, I'm not talking about abuse, just parenting decisions, that's not affected by it. I mean, that still would be handled if it had to through the court system in of itself, right? Because this doesn't affect BIC.
I think, as lawyers will, we could come up with a hypothetical that would stretch the bounds of it. But I think in your garden variety everyday case, where we're deciding whether somebody gets the standard possession order or the expanded standard possession order, that courts will give other courts leeway to make those decisions in a way that meets the best interest of the child. So I'm not, I don't practice family law. I practice with y'all, whatever law I'm practicing, I'm doing right now. But we have represented family lawyers for about 15 years or so, maybe more now. And we have not, from our membership, had people filter up to us a great deal of concerns. We ask those kind of questions, and I think they're fairly comfortable that what we're. It may change. I think early on it may very well change the arguments that people will make, but I think lawyers will be responsible in doing that. Swinging for the fences costs money, and a lot of people don't have that money to swing for the fences, as Jeremy pointed out.
Thank you.
Yes, sir.
Can I add something on your last question?
Yes, sir. Sir.
Yeah, actually, yes, go ahead, and then I want to get to Mr. Brown.
I was just going to let you know, there's actually a body of federal case law on that exact question of what do you do when you have two fit parents who are in a dispute like that. And the way the federal courts have handled that is they said essentially, look, these are two equal rights. They effectively cancel each other out, and the way you determine is you use the best interest of the child standard, which is Steve's point, right? But the way they conceptualize that is you have two equal rights in dispute, and so they effectively cancel each other out.
Thank you. That was my concern. Perfect. Thanks.
All right. Chair recognizes Andrew Brown. Andrew, I've got you on behalf of the Texas Public Policy Foundation, registered for HJR 112. Is that correct?
Yes, sir.
All right, go ahead.
Thank you, Chairman Leach, Vice Chair Johnson, and members of the committee. My name is Andrew Brown. I'm Vice President of Policy with the Texas Public Policy Foundation. I oversee our work on child and family policy. Thank you for the opportunity to testify in support of HJR 112. As has already been mentioned, this joint resolution would enshrine in the Texas Constitution the long-recognized truth that a child's parents have the inherent and fundamental right to raise their children and make decisions for their care, education, and upbringing. And both the Supreme Court of Texas and the United States Supreme Court have consistently recognized this fundamental right for over a century now. In fact, Supreme Court Justice Sandra Day O'Connor famously wrote that, quote, "The interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court." Specifically enumerating this right in our Constitution not only safeguards it, but guarantees that Texas families for generations to come will benefit from its protections. And although we colloquially refer to these rights as parental rights, I think the legal and historical understanding of that history emphasizes that it is the children of Texas who are the ultimate beneficiaries of these rights. And Vice Chair Johnson, I think this goes to the question that you asked. When you look at the history and legal precedent around these issues, it quickly becomes clear that the rights of parents to raise their children are derived and inseparable from their duties to their children. These obligations to protect, nurture, educate, and care for their children. In his second treatise of government, English philosopher John Locke describes the parent-child relationship as a form of natural government, in which the authority of the parent is intended only for the help, instruction, and preservation of their offspring. And this is also reflected by the great American legal scholar James Kent, who wrote in 1827 that the rights and duties of parents are so well secured by the strength of natural affection that it seldom requires to be enforced by human laws. And so when we see the way that parental rights are, and in fact family rights are applied, we recognize that parents only enjoy these rights so far as they exist to meet the obligation that that parent has to care for and nurture and educate that child. By safeguarding this all-important relationship through HJR 112, we can secure a prosperous foundation for Texas children for generations to come. Thank you all for your time, and happy to answer any questions you may have.
Members, any questions for Mr. Brown? All right. You do? Representative Flores.
I find that a little circular, in fact, because, I mean, what if you have bad parents? I mean, and they don't allow their, I mean, I'm concerned that a child should have an attorney ad litem or something, because you may have some parents who you would think that they would, by nature, have the best interests of their child's at heart. However, they may not in a perfect world. I mean, so I think it's really important that the rights of children are also protected and recognized, that sometimes if you're growing up, and no offense, a fundamentalist family, and they're or a case where they treat their children like their property, you want to make sure that somehow that information makes its way to the court so that these children are protected.
Right, and that's why the constitutional amendment and the law itself for over 100 years reflects that there must be a compelling state interest. It's not saying that this is an absolute shield and protects against decisions that would operate contrary to that parent's obligation to care for, nurture, and protect their children. This recognizes that occasionally, tragically, sometimes does happen. And it creates the opportunity and the avenue for the state to intervene when it is necessary to protect those children. But what it also recognizes is the state should be very limited in the interference that it can exert in the private realm of the family. And so the wording of this amendment accurately reflects the jurisprudence of not just this country, but the Western civilization, in the understanding of the parent-child relationship and how that is insulated from overreach from government.
Well, provided that there is a mechanism or a way for the best interest of the child to get known if it's being, not put forth by the parents. I mean, you got to be able to, somebody's got to be able to interfere. And somehow that information needs to make its way to give the state a compelling state interest. They can't just know it on their own. So and maybe I'm making a dumb argument, but I would
Not
just
at all.
think that somebody has to have, the child needs to be protected in and of themselves. They need to have certain rights that are inherent to them.
Right. No, and your concerns are well-founded and well-taken, and the structures that we have in place currently through, for example, the Department of Family and Protective Services are fully constitutional even when you apply this framework. That's been consistently upheld. Essentially, as Representative Frank mentioned, we are not creating any new right that has not existed for centuries. We're merely codifying that case law into a clear statement within the Texas Constitution in order to preserve that from erosion in the future.
Thank you, Representative Flores. Members, any other questions for this panel of witnesses? All right, thank you, gentlemen.
Thank you.
Okay, we've had some other people registered to testify. The chair calls Cecilia Wood, Jonathan Covey, John Schmood, and then the final panel of witnesses will be Sarah Lindley Bailey and Amy Lee Owen Klossel. Ms. Wood, let's start with you. Welcome back to the committee. It's good to see you. I have you registered on behalf of yourself testifying for HJR 112. Is that correct?
I'm sorry.
No, Cecilia Wood.
I thought you were talking
No,
to him.
maybe I should be more clear. I'll slow down.
Okay.
The chair recognizes Cecilia Wood on behalf of yourself registered for HJR 112. Is that correct?
That is correct.
Okay,
And
go
I
ahead.
should recognize my name. Thank you, Chairman.
Sure.
My name is Cecilia Wood. I have been practicing in Texas. I've been licensed in Texas since 1986, and I've been board certified in family law since 1993. And I have tried a lot of cases with a lot of different scenarios. As I was preparing for this again this morning, I read it again, CJC, which Mr. Bresnan referenced, and as I read the comment from them, it was like I couldn't have said it any better, so I'll just use their comment. The United States Supreme Court has long held that the Constitution protects the fundamental rights of parents to make decisions concerning the care, custody, and control of their children. This recognition stems from the strong tradition of parental concern for the nurture and the upbringing of their children. The Supreme Court's jurisprudence rejects any notion that a child is a mere chattel or creature of the state, but instead holds that parents generally have the right, coupled with the high duty, to recognize and prepare their own children for additional obligations. Accordingly, the care, custody, and control and nurture of the children reside first in the parents, whose primary function and freedom include preparations for obligations that the state can neither supply nor hinder. And this is not a new concept. The oldest case I found in Texas dates back to 1900, so it goes back even farther than the federal jurisprudence, where the state recognized this right. Getting courts to recognize this rights, getting laws to recognize the rights, these inherent rights that come by virtue of being a parent, has been an uphill battle. And I think that Mr. Bresnan was correct. We have a lot of statutes now in the family code that recognize that and that make reference to it. And so we've come a long way. We have a lot of case law that has been litigated in different, as a matter of fact, I gave you a very short outline because as I started going back through all my old briefs and things that I had written in 38 years, it's like, yeah, I can't bring all that to the courthouse, but you can call me and I can send you whatever you need. I think everybody's done a good job of kind of explaining how the history came along on this. So I want to make one comment that we not only want the right in the Constitution, because as we know, the feds could change things and then the courts could change things. We want the right in the Constitution. We also, some people don't like that we've put in the strict scrutiny test because they think that gives the government powers that doesn't give them any other powers than what they have right now. It just means that we're not going to change that test or ever lower that test. And even if we other courts do away with strict scrutiny in other areas. This, we're going to be looking out for, and in part because that is what protects the children, Representative Flores. It's something as a practical matter, because I have been doing this for 38 years. If one parent is, over controlling a child, I promise you, the other party will bring that to the court's attention, at which point, an amicus attorney or whatever would be appointed to bring out the child's interest. I've never seen in a contest where the other party had something bad to say, didn't say it. So I get your concern, but I think that the nature of the conflict brings it out. Mr. Bresnan said we can come up with a situation. I had a situation where two parents were named as joint managing conservators. They both wanted to appeal because they didn't like certain things. And the judge took both parents back into, or their attorneys, we went back into chambers so we weren't on the records, and said, well, if they want to have this hearing for temporary orders pending appeal, that's fine. But if they do, I'm going to take the kid and send him to a military school as far away as possible. Well, neither attorney could prove that was said, right? So the parents worked that out themselves. So I agree, there is federal law that basically, the way you think it through, it's like a cancel out. But the judge, I would say the only limitation on the judge and two fit parents is to do something like that, way outside of what either fit parent had decided was a good idea for their child. The last thing that I think that is important about this is that things change, pendulums swing. Before I couldn't find a case older than 1900, and that case actually cited other states because this wasn't on the government's radar that far back. So we never want parents, and because traditionally we feel that parents provide good things for their children, and so you have a right to liberty, but if you break the law, you're going to jail. And if you do something that is not adequately caring for your child, you might forfeit your rights. But by doing this, we give the citizens, because this is an amendment, we give the citizens of the state an opportunity to vote and to protect and preserve these rights for generations to come. Thank you.
Thank you, Ms. Wood. Members, any questions? Okay, thank you. Chair calls Jonathan Covey. Jonathan, I have you here on behalf of Texas Values, registered for HJR 112.
Yes, sir.
All right, go ahead.
Mr. Chairman, great to see you. Great to be back in your committee this session.
As well.
My name is Jonathan Covey, Director of Policy for Texas Values, testifying in favor of HJR 112. I think the previous panel and Ms. Wood did a great job. This is just basically a restatement of law as we already have it. And so we support this bill, and we support it for two reasons. One, for longevity, because parental rights are grounded in the 14th Amendment and cases like Troxel and Santosky and Lassiter and Prince, and they're too important to be left in a body of federal case law. They need to be in our Constitution. And then secondly, for clarity, because there are times when trial courts may need that clarity. Trial court and litigants, as Ms. Wood was talking about, need that clarity as well. So we appreciate Representative Frank bringing this bill. I do see this being mostly used during applied challenges where the law is not facially unconstitutional. So we just ask you to support this measure, and thank you for bringing it up.
Okay, thank you, Mr. Covey. Members, any questions? Okay. Thank you. The chair calls John Schmood. John, I have you here on behalf of yourself, registered for HJR 112. Is that correct?
That's correct.
All right,
and I'm also the Legislative and Policy Director of the Family Freedom Project.
Okay, do you want, I've just got you here on behalf of yourself. I don't have
Right.
your
That's
title.
fine.
Are you sure that's okay?
That's fine.
Okay,
Yeah,
all right.
absolutely. Thank you, Mr. Chairman, and honorable members of this committee. I should mention that I am a former state district judge. I was the judge of the 247th Family District Court in Harris County. So in that role, I presided over more than 13,000 cases, and I just figured members of this committee might want to hear from someone who actually was a family court judge. Just to reemphasize, HJR 112, of course, I know it's been repeated over and over again this afternoon, does not change our current law one bit at all. It merely enshrines into our state constitution the protection of one of the most fundamental liberties, one of the oldest liberties, deeply rooted in the history and traditions of our great state and our great nation, the right to exercise the custody, care, and control of one's child. The fundamental concept of liberty, which should unite all federal, state, and local governments, excludes any general power of the state to inject itself into the private realm of the family absent a compelling state interest and absent an interference that's narrowly tailored to remedy that compelling state interest. For more than 100 years, our nation's highest court has recognized the right to oversee the care, custody, and control of one's child as a fundamental right, secured by the Due Process Clause of the 14th Amendment to the United States Constitution. Ms. Wood quoted from, I recognize the quote, she quoted from Pierce versus Society of Sisters, which was actually a case that was decided by the U.S. Supreme Court in 1925. That's how old this fundamental liberty is. It's a component of substantive due process. In Washington versus Glucksberg, the court held that the 14th Amendment's Due Process Clause has a substantive component that provides heightened protection against government interference with certain fundamental rights and liberties, including parents' fundamental right to make decisions concerning the care, custody, and control of one's child. The court further stated that in a long line of cases, we've held that in addition to the specific freedoms protected by the Bill of Rights, the liberty specially protected by the Due Process Clause includes the right to direct the upbringing of one's children. Our nation's case laws regularly observe that the Due Process Clause of the 14th Amendment specially protects those fundamental rights and liberties which are objectively, specifically rooted in our nation's history and tradition. The right to the custody, care, and control of one's child is one of those most basic rights, one of the first rights recognized under substantive due process that is deeply rooted in our nation's history and tradition. More than 100 years of federal and state constitutional jurisprudence has consistently maintained that there's a presumption, and this is eloquently stated in Troxel versus Granville, which was a Supreme Court decision in 2000, that fit parents act in their children's best interest. And there's normally no reason for the state to inject itself into the private realm of the family absent a compelling state interest and provided that that interest is narrowly tailored to accomplish that compelling interest. HJR 112 very accurately memorializes the protection of a fundamental liberty, the right to exercise the care, custody, and control of one's child and to make decisions for the upbringing of one's child. The protection of this fundamental liberty is entirely consistent with state and federal constitutional jurisprudence. Also, the strict scrutiny test that is set forth in the bill very accurately sets out the test that's already in place whenever there is a state interference with a fundamental right protected under substantive due process. Our courts have made it clear that strict scrutiny is the proper test when dealing with a fundamental liberty under substantive due process, and HJR 112 perfectly memorializes that two-prong requirement for strict scrutiny. Again, in conclusion, HJR 112 doesn't change our current law at all. It merely enshrines into our state's highest governing document the protection of one of the most basic and long-held fundamental liberties that is so deeply rooted in our nation's history and in the traditions and history of our great state. Thank you very much for the opportunity to testify. I'm happy to answer any questions that anyone has.
Okay, Judge, thank you so much for that testimony. Members, any questions for this panel? All right, thank you. Appreciate you all being here.
Thank you.
The chair will thank you. It does come and go. Okay. Two other witnesses on this bill. The chair calls Sarah Lindley Bailey and Amy Lee Owen Clausel. Ms. Bailey, let's start with you. I've got you here registered as Sarah Lindley Bailey on behalf of yourself, testifying for HJR 112. Is that right?
Yes, sir.
Go ahead.
Good afternoon, Mr. Chairman Leach and honorable committee members. My name is Sarah Lindley Bailey, and I am here to advocate for House Joint Resolution 112, which aims to protect parental rights in the context of rare childhood illnesses. As a mother of a child who will forever be 4 years old, I understand this reality all too well. My toddler was a warrior. During Taylor's battle with cancer, I pursued every possible care avenue, yet my parental rights were often overlooked. I lived in fear, feeling pressured and intimidated from medical professionals and police officers. This is a reality that people live with in the hospital. Many parents face similar situations once their child is diagnosed with rare conditions. Do as the doctors say, or your child can be taken away. This is what I refer to as medical kidnapping. My child was on several medications, gabapentin, morphine, and fentanyl. It's a deadly combination, and yet I found out 3 days too late. I read medical studies as if her life depended on it, because it did. We lived in the hospital for practically half a year. I wanted to fire a doctor on day one for molesting my child, and I was told I did not have a choice in the matter. She punched him in the face. We were never going to have a professional relationship after that. And yet he denied blood cultures, he denied other issues. I was refused Benadryl, but again, morphine, fentanyl, and gabapentin were pushed. Child abuse physicians will get involved and make you look like you're the worst parent in the world if you are not doing as what they say. Again, medical kidnapping happens. Current laws do not sufficiently protect parental rights within the hospitals, often labeling us as neglectful or seeking alternative treatments or second opinions. Currently, I'm assisting another mother who lost her rights without going to court while her 6-year-old is on hospice. This is not okay. One mother who testified yesterday, her daughter was medically kidnapped, spending nearly $100,000 to regain her child's back into her arms to obtain her parental rights. This is not Texas. That is not freedom. Parents should have the empowerment to make the best decisions for their children and not create fear, especially in the hospitals. I urge the committee to support House Joint Resolution 112 so that parental authority remains respected and the families can navigate medical challenges without undue fear or coercion. Thank you for considering this crucial legislation, and thank you, Representative Frank, for authoring.
Thank you, Ms. Bailey. Members, any questions? All right, thank you. The chair calls Amy Lee Owen
Clazel.
Clazel.
That's okay. I might screw up your name too.
Amy Lee Owen Clazel. I have you here registered on behalf of yourself, testifying for HJR 112. Is that correct?
That's correct.
All right, thank you. Go ahead.
Yes. Good afternoon, Mr. Chairman Lynch and honorable committee members. Thank you for being here today and hearing everybody's testimonies. On this important legislation day, my name is Amy Lee Owen Clazel. I'm from Moulton, Texas in Lavaca County. I am for House Joint Resolution 112. I'm a mother of twin 5-year-old girls. I've had zero contact with them for over 10 months. It's heart-wrenching, I'm sorry.
It's okay, take your time. Michael, can you grab those tissues for me?
Parent rights is something that's, excuse me, thank you. Parent rights is something that's supposed to be between two parents, not between the government, CPS, the legal system, your mama, your daddy, your mother-in-law, your cousins. It should be between both parents. We know what's right for our kids. They share our DNA. We know what's best for our kids because we've been through it. We know how they are. We're instilled in them. I'm a victim of parent alienation. I filed for divorce back in November 2023 to get out of a toxic situation. My ex, Cody J., got mad at me for filing for divorce and used our broken legal system to punish me. He got the legal system involved. He went to the law enforcement, made false allegations that I've been beating him up for 15 years. He contacted CPS, making false allegations that I was unstable, I was a danger to my daughters, and the psychological abuse that I was put through and my daughters were put through and other parents that are put through the CPS system and our legal system is horrible, is traumatizing, and it's unnecessary. I support the Joint Resolution 112 to keep government out of our families and our marriages and protect our rights as parents and to protect our children and their well-being. This system really traumatized me and my daughters, and it's going to take years to correct this. And like I said, I'm not the only victim. Our family's not the only victim. There's many. I thank you, committee, for hearing my testimony today, and I ask for you to vote favor in House Joint Resolution 112. Thank you, State Representatives Frank, for authorizing this important piece of legislation. Thank you.
Thank you for sharing your story.
Yes.
Members, are there any questions for either of these two witnesses? Okay, thank you sincerely.
Thank you.
Does anyone else wish to testify on, for, or against HJR 112? Seeing none, the chair recognizes Chairman Frank to close on the joint resolution.
Thank you, Chairman. Just I'll try to go quickly, but I wanted to touch on just a couple things real quick. Representative Flores, I don't believe any of this will make it more difficult to remove a child in those situations where you need to. I'm happy to talk to you more on the floor. I don't think there's anything, this doesn't give actually more rights, but it does codify them. And I think, you know, when you look at it, we do a lot of things every session that make it more and more complex to assert your rights. This one actually makes it more simple. It takes all of the case law and simplifies it so that if somebody actually needs to assert their rights, and frankly makes it a little more easy for government to say, here's exactly the 2 criteria you have to have before you intervene. Doesn't stop you from intervening, it just makes it, I think, more clear. I will be happy to talk to either of those ladies afterwards to try to walk them through. That's been my life for the last 6 years, is working through the CPS world, but I don't think it really is impacted by this bill. But with that, Chairman, if anybody has any questions, I'd be happy to answer them. If not, I'd be even happier to just close.
Members, any questions for Chairman Frank? Okay.
All right, thank you. Appreciate
Thanks.
you hearing it. Appreciate y'all's support.
Of course, thank you. The chair will leave HJR 112 pending at this time. The chair now lays out House Bill 170. The chair calls on Chairman Guillen. I believe you have a committee substitute, and so the chair lays out the committee substitute to House Bill 170 and recognizes Chairman Guillen to explain the committee substitute.
Thank you, Mr. Chairman.
Thank you.
Members, allow me to illustrate how committee substitute for House Bill 170 would work. Imagine you own a house with a decent-sized yard surrounded by a fence. In the middle of the night, you hear someone climbing over the fence onto your property. Under current law, if you step outside and shoot that intruder, you're justified in using deadly force to protect your property and yourself, and you're granted civil immunity. However, if you brandish your weapon or threaten to use force, and the intruder is injured while retreating, you wouldn't have that protection. This is somewhat backward, as it encourages using deadly force rather than de-escalating the situation. House Bill 170 aims to address this by extending civil immunity to situations where you threaten to use deadly force, giving homeowners a wider range of options while still maintaining civil immunity. The ability to threaten to use force or deadly force is often enough to deter a crime or stop an attack without causing harm. Without this clarification, individuals who lawfully de-escalate a situation by issuing a warning or showing a firearm could still face litigation, even when they acted within the bounds of the law. Meaning, as my story above illustrated, under current law, the way to receive protection is to use force or deadly force. Additionally, the bill strengthens protections for those who are cleared of wrongdoing in the criminal justice system. HB 170 provides, or CSHB 170 provides that a person is presumed to be justified and immune from civil liability if a grand jury declines to indict them, if they're acquitted, or if charges related to their use or threatened use of force are dismissed. This prevents law-abiding Texans from having to relitigate their case in civil court after already being cleared in criminal proceedings. Furthermore, the bill ensures that individuals who are found immune from liability under this statute can recover reasonable attorney's fees, court costs, lost income, and other expenses incurred in defending themselves against a wrongful lawsuit. This provision deters frivolous legal actions and ensures that law-abiding Texans are not financially ruined for exercising their right to self-defense. The difference between the bill and the committee substitute is that it applies only to causes of action that occur on or after the effective date, ensuring that existing cases are handled under current law while providing clarity moving forward. We also incorporated language to specify that the actions leading to civil immunity must have actually occurred, reinforcing that the protections apply to real instances of justified self-defense. Members, the ability to defend oneself, one's family, and one's home should not come with the risk of financial devastation. HB 170 reinforces our commitment to protecting those who act lawfully and ensures that they're not subjected to unnecessary legal hardships. I want to thank the stakeholders for contributing to the committee sub. With that, I'm happy to answer any questions, and I believe we have some resource witnesses here who can help answer questions as well.
Thank you, Chairman. Okay, walk us through again the scenario that you mentioned at the outset of your layout, the problem that we're trying to address here.
Yeah. So
I want to make sure I understand, that we understand and have a clear view of what we're addressing.
you have an intruder, you shoot the intruder. Today, you have civil immunity. But if you don't shoot the intruder and the intruder breaks his neck on the way out, after you brandished a gun, scared him off, etc., you don't, under current law, have civil immunity. So we're correcting that.
Okay, Vice Chair Johnson.
Thank you. And you said intruder and triggering self-defense under criminal law, the Castle Doctrine or whatever else. If it's somebody selling magazines, or if it's somebody coming up because they want to talk to you about their religious preference, would the immunity apply if somebody pulls out a gun and tells those people to get off their property?
I don't believe so.
Okay, thank you.
Speaker Moody.
I'm sorry, I don't have the substitute language in front of me. What did it change?
I can give you my copy here, if you want.
That's fine.
Yeah, so.
Here, I'll give it my copy.
Yeah, so we,
I think that's it.
we made it to, in the committee sub, the difference in the committee sub is that it applies only to causes of action that occur on or after the effective date, ensuring that existing cases are handled under current law while providing clarity moving forward. We also incorporated language to specify that the actions leading to civil immunity must have actually occurred. And we also added that the criminal justice system language discussed about strengthening protections for those who are cleared of wrongdoing in the criminal justice system. We added that, and then we removed Section 3 of the original bill to focus the language while maintaining the bill's intent.
Actually, that's what I was wondering about, was the prior Section 3, which eliminated 9.06 in its entirety. So I thought that potentially could have different results than what you were looking to get to. So I have no questions.
So,
Okay. Yes, Representative Flores.
so just that, you have to have had an acquittal before you can get the immunity, I mean, in a criminal case, right? So in the scenario that Representative Johnson explained, if somebody breaks their neck, they're selling books or something, and somebody comes out and yells at them with a gun, says, "Get away, go, I'll shoot you," or whatever, "Get off my property," and that person retreats and gets hurt. Does there have to be, I mean, you said something like that if somebody got hurt, then the person brandishing the gun would be immune from
Right, I mean, if it.
civil liability. Is it only if there
somebody
was a
who's selling
failure to
books
indict?
comes- If somebody who's selling books comes to your house and gets injured because you scared them off with a gun, this would not apply to them.
It would not.
Just like it wouldn't apply to, if they were to kill that person, they wouldn't have immunity, no.
Okay.
Only threat.
Right, our bill is about only the threat, yes.
Okay. Members, other questions for Chairman Ginn? Okay. You've reserved the right to close. Let me call first panel of witnesses. Chair calls Chris McNutt, Gary Zimmerman, Bradley Hodges, and I assume a different Richard Hayes.
He's gonna testify.
So we've got Mr. McNutt, Mr. Zimmerman, you're Mr. Hayes.
That's correct.
Is Bradley Hodges here? Mr. Hodges, okay, we'll show him registered for the bill but not wishing to testify. Emily Taylor? And then the final panel, or the second panel, will be Fran Rhodes, Kyle Caruth, and Claude Whitaker. Mr. McNutt, let's start with you. I've got you here registered on behalf of yourself and Texas Gun Rights, registered for House Bill 170. Is that correct?
That's correct.
All right, go ahead.
All right, thank you, Chairman, members of the committee. My name is Chris McNutt, and as discussed, I'm president of Texas Gun Rights, and our stance is that you do not have a Second Amendment if you're not able to use it and without having the threat of bankruptcy and just financial devastation. So this bill is a priority of ours because it strengthens those protections, especially in cases where you have been criminally acquitted of a crime for justified use of force and deadly force. The standards for being convicted in criminal court are much higher than for civil court. So if you're fully acquitted of criminal charges, you should not be penalized in civil court. And we've got examples from multiple gun owners who have faced millions of dollars in civil penalties in spite of escaping any kind of criminal wrongdoing. So this would help prevent those instances. And there's actually probably other testimony here that'll go into some of that. But with that, I do strongly encourage everybody on this committee to support this bill. I think it's common sense, and I'm available for any questions.
Okay, members, any questions? Did you have a question?
No.
Okay.
Sorry.
Okay, all right. Chair calls Gary Zimmerman. Mr. Zimmerman, I have you here on behalf of yourself, registered for HB 170. Is that correct?
That is correct. As some of you may know, my name is Gary Zimmerman. I am a firearms instructor for the state of Texas as well as 3 other states. I'm here today in support of this bill because several years ago, I had to pull my weapon on somebody that came at me with a knife. And using Texas Law Shield, that made use of Emily's firm here, informed me that while I was in the right and I wouldn't be charged, and even the police said I wouldn't be charged, I was informed by them and the police that I could potentially suffer civil action. by the person that came at me with a knife. So this is a bill I would like to see definitely enacted and passed, because I pulled my weapon to protect myself. And as Emily's firm, as well as the police informed me, I had every right to do so. With me having every right to do so, why should I suffer civil penalties for doing something that was my Second Amendment right to self-protect? So I would like to see this bill pass, because I am somebody that was in that situation. Luckily, I didn't get sued. Thank you.
Okay. Members, any questions for Mr. Zimmerman? Okay, thank you. Chair calls Richard Hayes. I have you here testifying on behalf of yourself and Gun Owners of America, testifying for HB 170.
That's correct.
Is that correct? Go for it.
Yes, sir. Thank you, Honorable Chairman. Vice Chairman Johnson just stepped out. I'll answer a question she had in a moment. Members, thank you for having us to talk about HB 170. Gun Owners of America is in strong support of this bill. And I think, with the committee substitute, I think it alleviates the concerns that Representative Moody had. We're not touching Chapter 9 of the Penal Code. So if someone is objectively unreasonable, if someone is objectively acting when it's not immediately necessary, or they're objectively acting whenever they're using a disproportionate amount of force, this doesn't change any of that. So if somebody's a bad actor, they're still going to get in trouble. They are not going to get this protection under Chapter 83. So currently what we see under Chapter 83 of the Civil Practices and Remedies Code, if you use force or deadly force and your conduct is justified under Chapter 9 of the Penal Code, you're immune from damages. That's the current law that we have right now. The first fix is, hey, we need to add in this threat of force. I don't think the legislature ever intended folks to get sued over threats, because think about it. I mean, are you going to have really damages for this? But we've seen an uptick in lawsuits in this. But Chapter 83, I will say, for a very long time, held off frivolous lawsuits, but we have seen a huge wave and increase in these things. I'll say a 5-fold increase over the past 2 years. And so obviously it's not deterring folks from filing frivolous lawsuits against self-defenders, so we need to beef it up. The second part of that I wanted to talk about is this acquittal, no bill, or dismissal. It creates a presumption that the person's conduct is justified. Again, it's just a legal presumption. If the person is objectively unreasonable, it wasn't immediately necessary, used the incorrect amount of force, they can always disprove this presumption. But that presumption is there because we want to deter these lawsuits. Because ultimately, at the end of the day, and this fits in with our common law, the illegality doctrine, think about it in probate when you have the Slayer doctrine, you don't want the wrongdoer profiting from these things, and that's what we see happening across the state. We have a lot of folks who are the bad actors who go out and sue self-defenders, and they're losing everything that they have, and I think this bill is very important, and we'd urge you to support it.
All right. Thank you, Mr. Hayes. Members, any questions? Okay. Chair calls Emily Taylor. Emily, I have you here on behalf of yourself, registered for House Bill 170. Is that correct?
That's correct.
All right, go ahead.
Thank you, Mr. Chairman, committee members. My name is Emily Taylor. I am testifying for this bill on behalf of myself. I am a practicing attorney in the field of firearms and self-defense. My law firm, which is Richard Hayes Jr. is my law partner. We handle exclusively firearm-related issues, including self-defense murders, aggravated assaults, things like that, but also the ensuing civil lawsuit that does inevitably come. And I say inevitably because Richard is absolutely correct. We've seen a huge uptick in these cases because the plaintiffs' bars figure out how to game the system. And I say that as a criminal defense attorney, and I feel like I can be critical of the plaintiffs' bar here because people are critical of me. But they know that they can plead these cases as negligence. They're trying to invoke insurance policies. They're trying to invoke deep pockets. When they succeed in invoking insurance policies, that's great. All of our insurance rates shoot up, but it doesn't affect the self-defender as much, but it is still that frivolous lawsuit. Unfortunately, what happens more and more is they plead the case as negligence, and as an intentional act, the insurance company becomes wise to this, and the person who was acquitted or no-billed or otherwise justified in their act of self-defense is stuck paying out of pocket attorney's fees to defend the case. We believe particularly this section of the bill that adds in the provision for attorney's fees and costs, assuming that you are found to be justified under Chapter 9, as Chapter 83 would require, will deter the filing of these lawsuits because it is bad public policy to allow this to continue.
Yeah. Agree. Members, any questions? Okay, thanks to the panel. Appreciate you being here. The chair calls Fran Rhodes, Kyle Caruth, and Claude Whitaker.
I think Fran went over to us.
Okay, yeah.
I don't see Claude.
Kyle Caruth.
Yes, sir.
Is Claude Whitaker still here? Claude?
I do not see him.
Okay. Fran Rhodes. All right. I think Fran had to take off. We'll show her testifying for the bill, but registering for the bill, but not wishing to testify. Claude Whitaker is not here. All right. Claude Whitaker was here on behalf of himself and DD214 Security Services LLC. He's registered for the bill but doesn't wish to testify. Kyle Caruth, I've got you here registered on behalf of yourself and Gun Owners of America, testifying for House Bill 170. Is that correct?
No, sir.
Just on behalf of yourself?
Yes,
okay. Okay, and you're testifying for HB 170. Go ahead.
Yes, sir. Of course, with the last panel, they went through a lot of the legalities of this situation. And I wanted to bring a specific instance of this to light with you. November 5th of 2021. It was a beautiful day outside. I live in Lubbock, Texas.
Could you pull the microphone just a little bit closer if you don't mind?
Certainly.
Sorry.
Yeah.
Thank you.
I live in Lubbock, Texas, out on my farm. It is a working farm. I had, again, it was a beautiful day, November 5th of 2021. I had just gotten off of a phone call with the client, an oil and gas client, who had informed me that they were expanding their capital expenditure on a project that we were working on, meaning that myself and my employees had at least another 2 years worth of work. It was a wonderful day. And after I got off that call, I walked outside onto my front porch and was hand feeding, on my hands and knees, hand feeding my chickens on my front porch, when a man or a vehicle came flying up my private road on my farm, past a no trespassing sign, sliding to a stop with dust flying in the air, jumps out and says, "Where's my son?" It turns out that this man was the ex-husband of a woman that works for me. There were 3 individuals there that day that worked for me. There were 7 individuals there total that day. There are 3 videos of this as well, and I'll get into that in just a moment. He says, "Where's my son?" And I said, "Chad, you're trespassing." So he's now been trespassed twice. And he says, "No, y'all," meaning myself and his ex-wife, "are kidnapping their son, their youngest son." Their youngest son had been out of school all week, sick. I found out later that Christina, the ex of his, had been communicating with him all day since 10 a.m., telling him that she had taken the child back to the doctor and was still sick. The child was asking to stay the weekend with her, and would he allow that? He never did respond. And I can get into some of the stuff that I found out later as well, but to stick to what I knew that day, I knew that he was an ex-convict felon, a very violent individual. I knew that he had beaten Christina multiple times, in fact, attempting to kill their child, their first child, in the womb as well, broken her jaw, blackened her eyes, all of these on different occasions. I knew these things. I also knew circumstances where he went and intentionally bullied his way into fights. He had beat up a city councilman, a Lubbock city councilman, in the parking lot of Orlando's Italian restaurant. This dude he's a bad dude, and I knew that. And I knew that he had no business being at my home. There's no reason that he would even think that his child would be at his ex-wife's work. And in one of the videos, you can even hear him say that he has already called the police and has the police on their way to her mother's house. And she said, of course, why? And he said, it's because that's where the child was. And that is where the child was. And so if you have the police going to one place, why are you here? And if you think the child is here, then why are the police not coming with you? It was an obvious ruse. But again, as he said, y'all are kidnapping. I said, no, there's no one here. So he's aware, he was already aware, but he's aware that the child isn't there, nor is there any reason for the child to be there. From there, he told me to shut the F up, and I said, no, you get off of my property. At which time he, being about 6'3", weighing 250 pounds, and I am 5'8", and at the time I was 134 pounds, so he's literally double my size. He throws his hands out to the side and gets in my face and says, "Make me, bitch." Excuse my language.
That's okay.
At which time I put my hands up and I turned around and I walked inside and called the police. Again, I live out on a farm. I knew that the police would not be there at any reasonable amount of time. I knew that Christina was still outside with him, and he has a propensity towards violence in general, but also especially towards her. As the police are on their way, I do arm myself. I had the option of a pistol and a couple others. I got the absolute biggest gun that I could possibly get a hold of and went back outside and told him, without pointing it at anyone, told him to leave now. And he then said, "Do you think that scares me?" Again, bitch. He said, "You better effing use it or I'm going to take it from you and effing kill you." And that's all on video, every bit of it. From there, he actually grabbed the firearm and attempted to take it from me. Again, he's twice my size on my own front porch, picks me up by the rifle, slings me around, throws me off of my own porch, jerking the rifle back from me, attempting to take it as he had just told me he was going to. Luckily, as I told you, I grabbed the largest firearm that I had. It was tucked under my right arm, which I had a bruise from this instance for 3 weeks following. But as he jerked back, his hands came off and I retained the firearm. I landed, and seeing him coming at me yet again, I fired twice, and I did kill the man. And what I would like to say to you, one, is that no life is more important than any other. My life is not more important than his, nor his than mine. But he chose to forfeit that day. The police arrived finally, actually after I waving them down. The first police officer flew by. The second police officer flew by. The first one had turned around, flew by the other way. The second one finally saw me waving them down and came up. They, of course, investigated. They stayed there at my house for about 4 hours and investigated the entirety of the situation. I was never arrested. I was never charged. His new wife of 1.5 months was there as well. As I said, there were 7 individuals that were there that day. There are 3 videos of the entire ordeal. His new wife stated that she knew that criminal charges were not going to be brought on me, so they took social media action, and I'll get to that in just a moment as well. So at the time, I was married to a state district judge. I was in the process of getting a divorce. Did so very quietly, but nevertheless, as is proper, the DA recused themselves. All of the judges recused themselves. I knew every one of them. But it was only after extreme goading by the new wife and two of her children in particular that own a social media marketing company, sending letters to, of course, Joe Biden, to Governor Abbott, to Attorney General Paxton, to Attorney General Merrick Garland, to the FBI, the DOJ, the Texas Rangers, that they finally said, well, they're claiming that that I was not arrested that night because of political corruption, because of my wife, who was then a state district judge. So I believe Ken Paxton stepped in and held a special grand jury, which I'm sure most of y'all are very familiar with why or what the difference between a grand jury and a special grand jury is. And of course, one of those is political corruption in particular. And so I believe that's why Attorney General Ken Paxton convened a special grand jury, was to make sure that there wasn't political corruption associated with this, and in fact was a legitimate case of self-defense. The special grand jury heard 3 full days worth of testimony and evidence, including body cam footage and testimony from individuals that were there that day, and also character witnesses as well. They also saw all 3 of the videos, which, as I told you, there are 3. 2 of them are in the public, but the third being my doorbell camera, which shows the entirety of the ordeal from the time that he comes sliding to a stop on my property to the time that the police are there, still has not been seen outside of the grand jury. No one in the public has seen this. This is the most public that I have ever spoken about this as well. So again, as I said, this occurred on November 5th of 2021. And inside of that, we're over 3 years now. Inside of that, as I also stated, her 2 daughters were social media marketing gurus and had a company associated with such. So Ken Paxton convened this grand jury. They heard testimony and evidence for 3 full straight days. And at the end of that 3rd day, they said, okay, well, we're going to convene again in a month, and y'all can deliberate and decide what you want to do. The jury foreman said, no, I think we're ready to go ahead and deliberate now. They went back into chambers for 15 minutes and came back and unanimously no-billed me on the potential of 17 different charges, from my understanding, ranging from murder down to simple assault, down to negligent discharge of a firearm. I was found to have done nothing wrong. In the meantime, again, like I had stated, she said that it was clear that Ken Paxton had no intention of putting me in prison for murder, and so she went to the public. And again, the 2 daughters with the social media marketing company had 3 years of a field day, demeaning me, destroying my reputation, destroying my companies, having me canceled overall. They also went on to Good Morning America, also did a 12-part miniseries on YouTube, all of this, explaining how what was done was murder. She filed a $50 million civil lawsuit against me for wrongful death inside of that. And over the next period of time, of course, again, the local judges recused themselves, as is proper. They stated that that just shows it's further corruption. But as all of you know, if you know the individual, if you have a connection to the individual, you should recuse yourselves. So they continued this barrage of media and social media campaigns against me for 3 full years, the entire time pushing out the trial date. Trial dates would come and go and say, well, we need an extension. I finally got the new wife, her name is Jennifer. I got her set to be deposed in June of 2024. The day before, her attorney called my attorney, and unilaterally canceled that deposition and said that they just couldn't find another time until late August or September. So I got her scheduled for, I believe it was August 26th. It was that Thursday of that week. And again, in the meantime, I was deposed. Christina, the young lady that worked for me, his ex-wife, she was deposed, along with others as well. We had nothing to hide. I sat through depositions of myself and all of the other individuals, listening to the stories of how he would abuse his children, abused all 3 of his wives, including his current new wife. From there, I had her scheduled again for depositions August 26th of 2024. The day before, yet again, her attorney called my attorney and unilaterally canceled that deposition. It was very plain that she did not want to get under oath. She also said that they want out of the lawsuit and they need some sort of settlement to save face with their client. Now, I do have a non-disclosure agreement if, in fact, there was a settlement of any sort, so I can't speak to that. There are some, there is one newspaper article that does discuss a little bit of this for your reading pleasure, if you'd like. But inside of this, it took 3 years of my life. It cost me $500,000 in legal fees on the civil side alone. It cost me $46,000 on the criminal side, but $500,000, that was my entire life savings. I don't come from a wealthy family. I had put my companies together. And again, I'm still young, but especially at the time, you know, I was just barely getting my feet underneath me. But a plaintiff's attorney saw an opportunity. Oh, well, he's got an oil and gas company. Oh, well, he's got a development company. And there's this $50 million suit. And so a prominent plaintiff's attorney picked it up. And again, the process that I described a moment ago ensued. Finally, November 24th of 2024, this suit was in fact dismissed with prejudice. Luckily, it is over for me now. But I'm still stuck here trying to put my life back together. I've lost my companies. The 27 families that depended upon my companies for their livelihood, they lost their livelihood. I lost my livelihood. My children have been ostracized in their elementary and middle schools. Parents won't let their children come and spend the night with my children, especially at my house, because of all of this. My social standing has been completely destroyed. My life savings have been completely taken from me. I haven't had a dime's worth of income in over 3.5 years now. And I sit here today still in that situation. I don't know where I'm going to go with my life. I don't know what I'm going to do with my life. But what I do know is that someone who defends themselves legally and justly should not be put through a situation like this where they lose their livelihood, they lose their standing, they lose their social standing. Yep. I was on multiple boards and kicked off of all. And with all of that being said, there's certainly much more, and I'd be glad to answer any questions that any of you have. It was fairly high profile. It went around the world, if some of you have seen it. But I'd be glad to answer questions. I would implore you to please pass this bill. It does make complete sense. If you didn't do anything criminally wrong, why are we then rewarding those individuals that were in the wrong? We hear all too often in self-defense cases, the family comes out, oh, well, he was such a great father, or he was such a great, husband, or he was such a great person in the community, when in actuality, they were the perpetrator. And just as you had stated, Chairman Leach, that we need to stand with the victor, the victim, but the victor in this. And I ask that you do, that you stand with me and with all of the other individuals that have been wronged in this situation, in situations just like mine. Mine is an incredibly clear-cut case out on my own farm with a man who tells me he's going to take my firearm and kill me. and then tries to.
Yeah.
Thank you.
Mr. Kruth, thank you. I'm sorry about what happened to you, but I appreciate you being here, sharing your story. I'm sitting here as you're talking, reading through some of it, and the video's about to pop up. I'll watch that at some other point later, but seems pretty clear cut to me. Members, are there any questions for Mr. Kruth? Okay.
I will say that if you do search my name online, as I have said, I have not spoken. This is the most public that I have ever addressed this. And so if you look online at my name, you will find the terrible things that have been said about me and why people drive by my house even today yelling, screaming out, effing murderer, on why I've had thousands
Who
of
is this
death threats.
videotaping from the truck here?
So that is his new wife. Her name is Jennifer. She stated that their attorney had advised them to start taping custody exchanges. But again, they
Who
knew
did
where
Tony
the
Busby represent in that case?
Jennifer,
Which is who?
the woman that took the video, the new wife of the man that I shot.
And he's the one who sued you?
Correct.
That's interesting.
And I was told, going up into depositions, that, of course, it's Tony Busby. You know, expect to be deposed for 6 hours, if not longer, coming back the next day. He deposed me for 1.5 hours.
Is he the one who demanded a settlement from you?
He is.
And please don't breach any sort of non-disclosure or confidentiality agreement. You're not under any government order, certainly not here to do so, so
Certainly.
be careful. But, so he represented Jennifer, who demanded a $20,000 settlement, or ultimately?
Demanded a $10,000 settlement originally. That was the original ask whenever, after the second unilateral cancellation of the deposition, that was the initial ask right there, was $10,000.
Okay.
Again, that is not, I can say that because that was not part of any settlement. What I can say is that it was in fact dismissed with prejudice.
Sure, and I don't think Mr. Busby's from Lubbock, is he?
No, sir, he's from Houston.
Yeah.
There was a local attorney that originally filed the suit. It stated, written out $50 million, and then in parentheses, $100 million. And then they took that suit and shopped it around. And of course, Mr. Busby, I'm sure, saw that I had an oil and gas company.
Did they sue your oil and gas company?
They did.
In civil court, they sued and you said you had another company as well?
So a total of 4 that they sued that day. It was all of the companies that I had. So WC Land Services, my career.
You were on your home property?
Correct. On my farm.
On your farm?
Mm-hmm. And so they said that because I have a home office, as I'm sure y'all know, petroleum landmen are typically out in the county, in the county clerk's office, researching mineral rights and ownership and leasing. And so my office is actually my pickup, but I keep a home office. And the people that work for me are contractors, but also have, the ability for continuity to come there if need be.
Okay.
And they were there that day, or some of them were.
Fascinating. Members, any other questions for Mr. Caruth? Okay. Thanks for being here and sharing your story.
Thank you.
And yeah, it's been good to hear from you and to put more meat on this bone for us. So thank you. Really
I
sorry what
appreciate
happened
that.
to you.
And again, if you do look my name up, it's terrible things being said about me. They've had 3 years. The entire time I've had to remain silent.
Yeah.
Waiting on a determination of coverage for insurance on the civil. Of course, the criminal, that's the first thing they do is they don't talk.
Yeah.
So as y'all
We've got good, smart lawyers up here on this panel. We know not to believe everything we read online, and
Yes,
we know
sir.
the right things to look for. So
I appreciate
we've
that.
heard your story, and I'll just speak for me. I hear you loud and clear, and see the compelling reason for this bill. I do. So
Thank
thank
you.
you for being here.
Thank you, committee.
Yep. Does anyone else wish to testify on, for, or against House Bill 170? All right. Seeing none, the chair recognizes. Yeah. Do you want to testify? Yes, sir. Okay, come on up here to Michael, and he'll help you.
Yes, sir.
Oh, we've got you here. I called you earlier, you just weren't in the room.
Yeah, I had to go.
That's fine, that's fine. So Claude Whitaker, I've got you here on behalf of yourself and DD214 Security Services LLC.
Yes, sir.
Registered for the bill, correct?
Yes, sir.
All right, go ahead.
My name is Claude Brandon Whitaker. Excuse me, I'm out of breath. I had to run all the way from my
You're
parking
fine.
spot.
Take your time.
I'm testifying on behalf of myself in favor of the HB 170 bill. This bill provides protection against baseless lawsuits after I lawfully used force while on duty as a security officer. I was hit with the costly lawsuit that is still going on, even though the prosecutors found I acted within the law. This bill ensures that individuals who use legally justified force are not financially ruined by baseless claims. This bill stops lawfare against offenders. Without this law, bad actors can weaponize the civil court system to harass law-abiding citizens acting justifiably. Ensuring justice and deterrence, this bill protects innocent people from financial ruin and ensures that those who file baseless lawsuits are held accountable. By requiring bad faith plaintiffs to cover legal costs, it stops the legal system from being exploited for personal vendettas or financial shakedowns, keeping our courts focused on real justice. I'm actually the owner and operator of a security company in Houston, Texas, but I have locations out here in Austin too, which I just came from. And it's disturbing because I was hit with the lawsuit. I'm not sure if anybody's recognizing Greens Point areas, Houston, Texas, one of the worst places in Texas as far as crime. And I was actually sued for something that I acted justifiably in. And in the insurance company world, it's quick for them to just go ahead and settle something, even though my insurance doubled. So my insurance was already costly, and I feel like because everybody has an iPhone and they know the laws, working at clubs, working at apartments, working at warehouses, those aren't too bad, the warehouses, but the clubs, the apartments, especially the lower income ones, the first thing out of people's mouths, they want to run up to you and tell you what they do and what you can't do, and they try to provoke situations. Now, in this situation, it was a bad guy that attacked me, and just defending myself, I was arrested, and it was justifiable. The police didn't do anything in the reports to write things correctly that would have kept me from being arrested. That's here or there. But at the end of the day, once the lawyers got the evidence on what happened and the case was already dismissed, they still filed the claim. Evidence was wrong as far as the people that they were filing the claim against. And the apartment video showed there was people that lived in the apartments that said everything that happened up until the incident. There was probably about 6 witnesses on my side, none on his. And after that happened, like I said, my insurance doubled. And it's hard because in the state of Texas, with all the crime going on, especially in the city of Houston, you have security companies where you can't really do security because everybody's going out trying to find a way to file a lawsuit against you. And I just feel that at this time with the high-rated crime in the city of Houston, the last thing we should do is make it easier for lawyers to file things incorrectly, and then even getting to beating the case, you shouldn't have to be there. But even once you beating the case, there's nothing you can do. You're just harmed for the rest of, I don't know when my insurance is going to go down, but it doubled just because of that. And there was video evidence and everything else, which is what got it dismissed. So those are things that I'm sure are going to harm other companies along with mine. And as a veteran-owned business, I feel like, I'm here to serve, to protect, just as I did when I was in the military in service, and it's just totally opposite. It's almost like they're saying, we don't really want you to do security, which is why I do it. That's what I did when I served overseas in Iraq and here, and it's like, okay, you don't really want me to do security because you're letting all these people do things that can affect doing proper security, which has put you in a lawsuit. So that's all I wanted to say.
Yeah, thank you for your testimony. Vice Chair Johnson.
Which branch?
I was in the Army.
Thank you
Yes,
for your
ma'am.
service.
No
Thanks
problem.
for coming to testify.
You're welcome.
Yeah,
Thank you.
Mr. Whitaker. Appreciate it. Members, any other questions? Thank you. Glad you came back and testified. Does anyone else wish to testify on, for, or against House Bill 170? Seeing none, the chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. If there's no further questions, I'd ask for your favorable consideration.
Okay. Members, any questions for Chairman Guillen? Okay, seeing none, we'll withdraw the committee substitute to House Bill 170 and leave House Bill 170 pending at this time. The chair now lays out House Bill 786 and recognizes Representative Jones to explain the bill.
Good afternoon, Chairman Leach and my esteemed colleagues and guests. My name is Jolanda Jones, and I'm here to introduce House Bill 786. But before I do that, I want to take a moment to be a really proud big sister. The lady sitting back here who does not have on her medical coat is the doctor of the day today.
Oh, great.
And she
Welcome
is my
to the committee.
sister, Dr. Uchenna Jones Conley.
Say your name again? Okay. Well, welcome. Welcome. We're glad you're here. Welcome to committee.
You
We hope,
heard the
to not
Jones
need
part,
you
right?
over the next, hope to not need you over the next 10 minutes.
Okay. So
But we're glad you're here anyways.
I'm honored to present this local bill aimed at enhancing security in our justice courts, particularly in counties with populations of 3.3 million or more, which, by the way, only applies to Harris County. As we all know, ensuring the safety of our courts is crucial to maintaining the integrity of our justice system, and this bill will address an important gap in court security. The bill overview, this bill proposes a simple but necessary requirement that the commissioners' courts of counties with populations of 3.3 million or more provide security for justice courts. Again, it's only Harris County. Specifically, it mandates two things. Number one, a metal detection device at every public interest. And number two, a constable, deputy constable, or deputy sheriff at every door open to the public. This provision is in response to increasing concerns regarding the safety in our courthouses, particularly in high population areas. This bill is designed to be fiscally responsible. First, it directs the use of funds from the county's courthouse security fund, which is specifically set up under Article 102.017 of the Code of Criminal Procedure. If necessary, additional funds may be used from the county's general revenue fund, but the primary goal is to minimize the financial burden on taxpayers by utilizing existing resources where possible. In terms of state impact, the fiscal note associated with this bill indicates no significant fiscal implication for the state. This means that the implementation of this bill will not impose an undue financial burden on state budgets, and there have not been any riders filed related to this bill. The focus of this bill, again, is on Harris County, which includes a large number of justice courts. There are currently 16, many of which have served very busy urban areas where security concerns are heightened. Unfortunately, not all of these courts currently have comprehensive security screening in place, and this bill aims to address that gap. Implementing metal detectors and having law enforcement personnel at entrances will significantly improve safety for judges, court staff, and the public. In a real-world context, and I guess Vice Chair Johnson knows the person I'm about to talk about. We are living in a time when court security is more important than ever. In 2017, Deputy Constable Clint Greenwood tragically lost his life in the line of duty outside of a JP court. Let me say this about Clint. When I started practicing law, he was in the DA's office, but before that, he was law enforcement, went to law school, very fair DA. That doesn't always happen, but he was, and then at some point he switched to the defense side. Very good defense lawyer, fought hard for his clients, and when young lawyers like me needed his advice and counsel, he was happy to help. At some point, he started working out, why can I not remember where he was working? Baytown, at the annex there, which is in Harris County, and he ended up being shot in the parking lot. And it was horrible. So while this bill is not a direct response to that tragedy, it is an important step in preventing similar incidents in the future. We must prioritize the safety of our justice system participants. I will also tell you this, I didn't come up with this bill. I had a number of JPs come and tell me they want safety. If you go into any court in Harris County that is not a JP court, most likely there's gonna be the metal detectors that are there. You walk through and it'll go off. And some they have x-ray machines. I filed this bill last session Now Rep. Lauterbach supported it last session. And so a lot of the smaller places says we can't afford those machines. And in some JP courts, they don't have their own buildings. I didn't know this. And they do it out of their houses sometimes. Who knew? And so I changed it to add only a metal detection device. So that means a wand. So even then, it's not super expensive. We also believe just the JP and Constables Association is supportive of this bill. They're the ones who brought it to me last session. So this bill is a proactive approach to security that will help prevent violent incidents and ensure that those seeking justice are able to do so in a secure environment. This bill will also provide better protection for law enforcement personnel who work tirelessly to ensure public safety in our courts. And we should have speakers. Okay, so we do have a speaker. I will let him come up, but I don't think that because your fight is in a JP court, that you should have any less security. When you're evicting people, some people get very, very, very angry. Warrants are issued by the JP courts. As again, Mr. Woolley will explain that to you, but I will yield now to the speakers.
Well, hold on. Members, any questions for Representative Jones? Okay, now you go. Thank you. The chair, you've got one witness who's registered for the bill and wishes to testify. The chair calls General Woolley. With Judge Woolley, good to see you. With JPCA on behalf of JPCA and yourself, registered for the bill. Is that correct?
That is correct,
All right, go ahead.
Thank you for having me here today. It's my honor and pleasure to be here. Some of the things I'd like to discuss about this bill, JP courts, if you look across the state, we're not located in the main courthouse. And just as Representative Jones said, the main courthouse usually has pretty significant security measures. The annex buildings across the state usually do not. Those of us that are protected are fortunate, but as she said, there's some that aren't even in a county building. I'm aware of one JP court that practices or holds court at his auto parts store. So there's some significant issues with that. Kind of what she alluded to, if you look at the big picture of our judicial system, it may seem that justice court cases are minuscule in that big picture. But the litigants that come in our court, those cases are a big picture for them. They're being evicted from their houses. The other thing that she mentions is we sign warrants. I sign warrants against cartel members. That's concerning. That an issue could come back to my court on that. And now there is some fiscal impacts. There is a court security fund, and if the county has annexed JP courts, then there is a percentage of the court security fund that's collected through the court fees that goes to that fund. Probably address that at a later time on what some of that change could be made there to give us a little bit more of that cookie. We support this. We also have a couple other court security bills this session that we're supporting. But I want to make it clear, too, that this protection is not just for judges and staff. Justice courts handle the majority of the cases in the state of Texas. This protects our citizens because that's who's coming to justice court. And it is imperative that we do that. It's not a matter of if, or a matter of when something's going to happen. If something's going to happen, it's a matter of when. And justice courts deserve the same protection that the other courts across this state have. You don't walk into this Capitol without going through one. You shouldn't walk into one of our courtrooms without it, too.
Okay. Judge, thank you. Members, any questions? All right, thanks for your testimony.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 786? Seeing none, the chair recognizes Representative Jones to close on the bill.
In closing, Mr. Chair, this bill is an important step in the modernization and securing of courtrooms for the reasons Judge Woolley said, to protect the judges, the police, the court staff, and most importantly, the constituents of whatever justice courts they're in. If you go to any other court in Harris County, district, municipal, probate, federal, and bankruptcy, there are metal detectors and scanners, not just wands. It should be no different just because you are in JP court. The issues are real, and evictions and civil judgments are important to litigants, and we just want everyone to be safe. I urge the committee to support this measure, which will improve safety in some of our busiest and most densely populated counties. I look forward to any questions in this closing or discussion and appreciate your favorable consideration on this very important bill and issue.
Thank you, Representative Jones. Members, any questions? Okay, thank you.
Thank you.
The chair will leave House Bill 786 pending at this time. Never mind. Let's go forward. Okay, members, our final bill of the day, we're going to hear Representative Isaac's bill, House Bill 1130, and then immediately following that, we're going to vote on some pending business. So the chair lays out House Bill 1130 and recognizes Representative Isaac to explain the bill. I think there's a committee substitute.
Yes.
Is that correct? Okay. Representative LaHood lays out the committee substitute to House Bill 1130, and the chair recognizes Representative Isaac to explain the committee sub. Go ahead.
Chair Leach, Vice Chair Johnson, and committee members. Yes, the committee substitute, I'm going to make this really quick. I've talked with each and every one of you on this committee about this bill, so it's going to make this really fast. As drafted by legislation, the Legislative Council was drafted in accordance with a previously adopted bill from the ADA legislature regarding liability protections for RV parks, House Bill 2636. This substitute, we added a single sentence for consistency to make sure that the statutes were alike to remain agreed to. So, as substituted, this provides common sense liability protections for cavern operators is exactly the same as House Bill 2636 by Representative Murr that gives RV parks the same protections as last session. Both Texans for Lawsuit Reform and Texas Trial Lawyers Association have worked cooperatively on this bill and are in support. House Bill 2636 passed the House last session, 141 to 0. Do you have any questions? I'm happy to answer any questions.
Okay. Members, are there any questions for Representative Isaac? Okay. Thank you. You've got one witness. You can stay there. You can go
Yes.
back to your seat, whatever you
do
want to
have
do. The chair calls Winter Presapio? Presapio. Italian?
Italian, yes.
Winter Presapio
Thank you.
from Natural Bridge Caverns, testifying for House Bill 1130. Is that correct?
Yes, sir.
Okay, go ahead.
Chairman Leach and members of the committee, thank you for providing time to hear from Show Caves in Texas. I'm here to support HB 1130, brought to you by Representative Isaac. My name is Winter Prosapio, and I'm here representing the largest show cave in Texas, Natural Bridge Caverns. You were probably there at 5th grade. Please come back. We're a family-owned tourism destination, and I've also worked with the National Caves Association and the International Show Caves Association, representing thousands of show caves in the nation and around the world. Here in Texas, most caverns that are open to the public, referred to as show caves, are small businesses. They're locally owned, generally by families like ours. The land where Natural Bridge Caverns was discovered has been in the family for 5 generations. When it opened in 1964, then Texas Governor John Connally named our cavern a jewel in the crown of Texas attractions. So developing a wild cave to allow touring by the public is a careful process. It's critical that we preserve the cave environment with minimal impact, but provide safe access for our employees and our guests. Our show caves are a precious natural resource, part of the aquifer recharge zones, home to rare cave-adapted species, paleontological and cultural and historical sites. We have spent literally millions of dollars creating a safe and exciting experience for our guests. But despite that, we're repeatedly hit with frivolous claims, everything from people bumping their heads in areas where we have told them to duck, not holding onto handrails, slipping, not watching their step while going downstairs, or guests coming into contact with wildlife. Squirrels, mostly. In some cases, our insurance company chooses to pay these claims rather than fight them, even though we are not at fault. Now, as someone who has in a previous lifetime worked on tort reform, it's frustrating to see these types of cases. They clog the courts, they cost tremendous amounts of time and money, they increase our operating costs as our insurance rises, and they compromise our confidence in a system designed to address negligence. I believe the more that people know about the incredible sights right under their feet, the more vested they will be in protecting these natural Texas wonders. House Bill 1130 will help protect our small show cave businesses and natural wonders for generations of Texans while ensuring that operators maintain safe conditions for guests. As Representative Isaac mentioned, this bill has been reviewed and drawn up in cooperation with Texans for Lawsuit Reform and the Texas Trial Lawyers Association. That alone is, a remarkable thing, and we hope we can count on your support.
Okay. Thank you. Thanks for your testimony. Members, any questions for the witness? All right. Very helpful. Thank you. Does anyone else wish to testify on, for, or against House Bill 1130? Okay, seeing none, the chair recognizes Representative Isaac to close on the bill.
If there are no questions, I close.
Okay, members, any questions? All right. Thank you, Representative Isaac. The chair will withdraw the committee substitute to House Bill 1130, and we'll leave House Bill 1130 pending at this time. Okay, members, we're going to vote on a few pending items. The chair lays out House Bill 171 as pending business. Members, this is Chairman Guillen's bill that we heard last week relating to the certificate of medical examination for chemical dependency and the duration of court-ordered treatment for a person with a chemical dependency. Are there any questions? Okay, Representative Gonzalez moves that House Bill 171 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach,
Aye.
Johnson,
Yes.
Dutton, Moody, Landgraf, Schofield, Gonzalez, Flores, Hayes, LaHood, Dyson,
Seven. The chair, there being 7 ayes and 0 nays, the motion prevails. The chair lays out House Bill 204 as pending business. Members, this is Chairman Tepper's bill that we heard last week relating to the total annual salary from state and county sources for certain state prosecutors. There is a substitute. Representative Hayes, Vice Chair Hayes, offers up that committee substitute. Members, this is the substitute that we laid out last week. Rather than applying the provisions to a district attorney, the substitute applies the provisions to a state prosecutor, meaning a district attorney, criminal district attorney, or certain county attorneys performing the duties of a district attorney. Are there any questions? Is there any objection to the adoption of the substitute? Seeing none, the substitute is adopted. Representative Schofield moves that House Bill 204, as substituted, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach,
Aye.
Johnson,
Yes.
Dutton, Moody, Landgraf, Schofield, Gonzalez, Flores, Hayes, LaHood, Dyson,
There being 8 ayes and 0 nays, the motion prevails. The chair now lays out House Bill 349 by Representative Lulu Flores. This is the hot dog bill. The chair lays out, this is relating to civil liability for removing certain individuals or animals from a motor vehicle. Are there any questions? Seeing none, Representative Johnson moves, Vice Chair Johnson moves that House Bill 349 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach,
Aye.
Johnson,
Yes.
Dutton, Moody, Landgraf, Schofield, Gonzalez,
Yes.
Flores, Hayes, LaHood, Dyson,
There being 7 ayes and 1 nay, the motion prevails. The chair lays out House Bill 917 as pending business. Members, this is Representative Spiller's bill relating to a district or county attorney participating as counsel in certain proceedings. Are there any questions? Seeing none, Representative Flores moves that House Bill 917 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach,
Aye.
Johnson,
Yes.
Dutton, Moody, Landgraf, Schofield, Gonzalez, Flores, Hayes, LaHood, Dyson.
There being 8 ayes and 0 nays, the motion prevails. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there any objection? Hearing none, the committee stands adjourned, subject to the call of the chair.